Hello, everyone, and welcome to the Employment Law Counselor Podcast presented by White & Williams, LLP. I'm your host, Jeff Stewart, and we're glad you found us. Our goal here at the Employment Law Counselor Podcast is to give you insight into the practical application of the world of employment law from the view of two seasoned attorneys. Each episode, we will focus on one specific employment law, how it came to become law, what parts of the law are relevant in today's workplace, and some tips to ensure that you and your company stay in compliance with that law. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. Today, we'll be covering the Family and Medical Leave Act, better known as the FMLA. And I'm thrilled to be joined once again by George Morrison, who practices with me out of our Lehigh Valley, Pennsylvania office. How you doing today, George?
Great to be back, Jeff. Doing well?
Good. Glad to hear it. Are you ready to dive into the wonderful world of the FMLA?
Absolutely. Let's do it.
All right. Let's do it. So for our listeners, I always like a little history of the law. And the FMLA is significant in that it was the first piece of major legislation signed when Bill Clinton was elected to office the first time. So in 1993, the FMLA came into being. So George, why don't you tell our listeners what the main purpose of the law is?
I think the good starting part about this is that the FMLA is different than a lot of other employment laws that we may come across in our day-to-day activities. So this is not a workers' compensation law. Instead, the FMLA is really focused on job protection and making sure that someone is able to return to a position if they suffer from, the legal phrase is, a serious health condition. And I think it's best stated by the Department of Labor. I pulled this off their website earlier this morning of how it views the FMLA. And this is a quote. The FMLA serves as the cornerstone of the Department of Labor's efforts to promote work-life balance. And we have worked in support of that principle that no worker should have to choose between the job that they need and the family that they love. And I think that's a great summary of what this law is all about, and it serves as a great starting point for today's discussion.
I like that. That was the Department of Labor?
Believe it or not, it was the Department of Labor.
Wow, they're not usually so eloquent. I like it. All right. I think the other thing to really focus on, and you mentioned it, is that this is not a paid leave or a compensation leave of any kind. The FMLA provides unpaid leave. Now, there are options for an employer to substitute paid leave for unpaid, but the entitlement itself is unpaid leave. What a lot of people don't understand, this is one of the misconceptions in this law, and usually it's misconceptions on the employee's part because employers understand this, is that not all employers are covered by the FMLA. This is not like minimum wage where everyone is covered. This is instead only certain employers. So, George, can you kind of run through what employers are covered by the FMLA?
Sure, Jeff. It's all about the numbers when it comes to the applicability of FMLA to a particular employer. The legal rule is that you have to have at least 50 employees and 50 employees within a 75-mile radius for the FMLA to apply to that particular work site. A lot goes into calculating, well, how do we get to that 50? Do part-time employees count? Do people that come and go off payroll count in a given week? And the answer is generally yes. If someone's name is found on a payroll roll, for lack of a better phrase, they count towards that 50 number. Maybe unpaid volunteers do not count. The thought process there is that, as you mentioned, you're allowing someone as a matter of right to leave the workplace, which, as you can imagine, can cause some disruption. As part of the development of this law, 50 became the magic number, with the thought being that, well, if someone does leave the workforce, there's enough people behind that maybe job duties or responsibilities could be assumed during that time period.
Yeah, and that makes sense when you think about it, because if you had an office with only 4 people, and let's say 2 people needed leave at the same time, that's half your workforce. You wouldn't be able to get anything done, and that would be a major hardship. But at 50, it seems like a decent number where job duties can be absorbed by the remaining employees. And that's really what it is. And that's the number that Congress came up with. It's not a magic number. I don't believe there were any studies done. I think they just said, that sounds like a good number. And that's what's in the law itself. Now, just like there are certain numbers that need to be met for employers for the law to cover. The same thing goes for employees. Not every employee is covered, even if they work at an employer or at a workplace that is covered. So, George, do you want to run us through some of the eligibility requirements of the employee?
That's exactly right. So just because the FMLA may apply to a covered employer does not automatically mean that every employee that works at that entity is going to be eligible to take leave. And this, again, there's a lot of numbers that become involved. The first requirement of which is that the person, number one, works for a covered employer. Second, the person has been employed at least 12 months prior to the start that leave is to commence. The other magic number is that the employee has to have worked at least 1,250 hours during the 12-month period prior to when leave is supposed to commence. And then again, to be an eligible employee, you have to work at a work location that has at least 50 employees within that magic 75-mile radius. So a lot of numbers, a lot of technical requirements as to eligibility on the employment front and the employee front as well.
Yeah, and we talked earlier a little bit, we referenced it, that this is unpaid leave. And what the FMLA grants is up to 12 weeks of unpaid leave in a 12-month period. And that leave can be taken all at once, or it can be taken intermittently. And for purposes of today's discussion, we are not going to talk about intermittent FMLA. I promise you that will be a future podcast, because frankly, it could probably be 2 or 3 podcasts with all the questions that we get about intermittent FMLA leave. So we're going to talk specifically about taking the 12 weeks or up to 12 weeks in a block, because somebody could need 6 weeks, 8 weeks, and that's fine. And I mentioned earlier that it is unpaid. However, an employer can require you to use sick or vacation time that you may have as part of that leave entitlement. And the important thing to know there is it does not extend the entitlement. In other words, if you're required to take 3 weeks of vacation as part of your FMLA leave, you would have 3 weeks of paid, 9 weeks of unpaid, still for a total of 12. You would not have 3 weeks paid and then 12 unpaid. It doesn't work that way. The total leave entitlement is 12 weeks, no matter whether it is paid or unpaid. Now, George, there's a number of different qualifying reasons that someone can ask for FMLA. Do you want to go through some of those? Because there's really 5 big categories. Do you want to hit those for our listeners?
Sure. Yeah. So, again, a lot of restrictions, a lot of regulations surrounding FMLA leave and when an employee is eligible. And the focus with respect to when the right may trigger also takes into account the qualifying reasons that Jeff just mentioned. Some of us are probably familiar with these, but the first being if there's a birth of a child, or there's an adoption, a placement of a child into the home, that would be a qualifying reason for that 12 weeks of leave. And then we deal with the different situations with respect to a serious health condition. FMLA leave, as the name may suggest, gets into situations involving medical concerns of an individual, an employee. First, if the employee is suffering from a, quote, serious health condition, close quote, and I think Jeff will ask me a follow-up question about what that means, the leave entitlement triggers. If an employee's immediate family member is suffering from a, quote, serious health condition, the leave entitlement would trigger. And then the final 2 categories, 4 and 5, deal with military. In the event someone is deployed, a family member is deployed, FMLA 12-week would trigger. And if a service member is suffering from a serious health condition, that individual, if they're caring for someone in that category, can actually get above the 12 weeks, up to 26 weeks of leave under that circumstance. And that was recently added in 2008 to the family FMLA.
Yeah, so you used the term serious health condition a couple of times, and I think it's good for our listeners to know what that means. And the regulations for the FMLA say that a serious health condition means an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. So that's a pretty broad definition. Wouldn't you agree, George?
Absolutely. It's less than disability. And I'll tell you this, I've had a number of cases where that very issue is litigated, and taking a very close look, for example, inpatient care versus just a quick visit to the ER where you're not admitted, can make the world of difference of whether FMLA is triggered and whether there could be liability if you find yourself in a case.
Absolutely. Now, you also mentioned, that you could take FMLA leave to care for a family member with a serious health condition. Is that any family member? Could I take care of my third cousin twice removed?
No. So it's immediate family. So it's not grandparents. With respect to serious health conditions and immediate family, we're talking about sons, daughters, parents, for example, basically one rung above, one rung below. That's when that entitlement would be involved.
Yeah, and in fact, the law does recognize that if you were raised by your grandparents, in other words, they stood in place of your parents, then you could, in that limited circumstance, take the leave to care for a grandparent. Or if you are a grandparent and taking care of a grandchild, you could take the leave for the illness of that grandchild. But that's a very limited circumstance. Now, what I find interesting in the FMLA, and I'm kind of an employment law nerd to a certain extent, so I find things interesting that others might not, is that rule of immediate family member is actually different than what is considered a military caregiver, where they actually expand that definition. And instead of using immediate family member, they use the term next of kin, which goes spouse, parent, son, daughter, but then there's actually a legal priority of who is the next of kin that might be able to care, being a grandparent, then aunts, then aunts and uncles, then first cousins, and on down the line. So it's not a one size definition when it comes to family member for purposes of the FMLA. Let's shift gears a little bit here, George, and let's talk about how an employee actually gets FMLA leave. Obviously, they can ask directly, but what does an employer have to do if they know of a need?
Yeah, the threshold is very low in this area, and it's very similar to the interactive process under the ADA, that if the employer has a reason to know, whether either direct oral or written request from the employee, they find out that someone is in needs potential leave from another employee, or it's just completely obvious, certain obligations trigger at that moment. And the obligations are to follow up with an employee and determine whether what is at issue is a serious health condition or the other qualifying events are on the table. If we make that determination, the typical process then is to begin the FMLA process, which would include providing, for example, notice that the person is eligible for leave, that they meet basic eligibility requirements. Another step of the process would be providing the FMLA certification form, where that is provided to the employee. The employee will take that to their primary care physician or a medical provider that is caring for them for that particular health concern. It's completed, and ultimately a determination is made as to whether approve the FMLA request or deny the FMLA request.
And you mentioned the forms that are used, and this is an area where normally I'm not a fan of government forms. I think that they're usually not easy to follow and they're difficult to read, etc. I'm going to say this is the exception that proves the rule. The Department of Labor's forms for FMLA, I think, are as good a government form as there is, because it really walks employers through a lot of questions that they may not have thought about along the way. For example, there are areas of talking about eligibility to ensure that the employee has met the eligibility requirements. There's a section where it asks the employer what the plan is for any health insurance contributions for an employee during their period of leave, because many times an employee will be paying some portion of their health insurance. So let's say that the employee is paying $200 every pay towards their health insurance benefits. Well, if they're on unpaid leave and not receiving any pay, is the employer expecting them to write a check to the employer? Is the employer planning on essentially taking double deductions once the employee comes back and is in paid status? What is being done? And setting that out at the beginning of the leave or at the time of approval of the leave I think is incredibly important. And I'm just curious, George, I know I advise my clients always to utilize the Department of Labor forms. I'm assuming you do too, but do you find them as useful as I do?
Yeah, I completely agree. And it's definitely what we coin in this industry a best practice to use the forms that are issued by the Department of Labor. In my view, they're helpful not only for the reasons that Jeff just mentioned, but also because the amount of regulations that apply with respect to what has to be in particular notices, designation forms, so on and so forth. The government's version of those forms, number one, they're written by the government. So that kind of alleviates concern that there's going to be some rogue compliance issue, but they do comply. They comply with the regulatory framework that's around the FMLA. And, at the end of the day, that's why it's a best practice. And that's typically what most employers are doing. And sometimes it's beneficial to be in the pack. And this is one of those situations.
Yeah, the other area where the FMLA designation form, I think, makes an employer make a decision early on is whether they're going to require the employee to check in every so often. If they're going to be out for, let's say they're going to be out for 12 weeks, are we expecting to get a call once every 3 weeks or 4 weeks, just kind of get a status update, make sure everything is still on track to be returning? Or are we expecting to hear nothing from the employee? Because I know that can become a source of frustration for many employers is if they hear nothing from someone for that entire leave period. George, I talked a little bit about what I enjoy about the designation form. And there is not just the designation of leave form from the Department of Labor, there's a separate form to be sent to the healthcare provider. Can you go through some of the highlights of that form for our listeners?
Sure. And again, I think the major highlights there are getting feedback from a medical provider to confirm that there is a serious health condition, getting feedback from the provider of the type of leave that would perhaps be most beneficial for this individual. Will it be a continuous leave where, the person will be out for a set period of time? And what's helpful is that many times that provider will set forth an anticipated return to work date, which is very helpful with respect to operations so that there's a set plan as to when the person would be re-entering the workplace. And while not a topic of this podcast, it would also provide information whether the leave would be intermittent and the nature of how it would look. And again, important information being obtained because many employers view FMLA as extremely disruptive, and admittedly, it does kind of shake everything up. So the more information you have about these basic concepts, such as return to work, can go a real long way in planning to ensure operations are continuous.
And I know I get this question from employers regularly. What do I do if I don't understand what I got from the doctor? Can I call the doctor and ask them to do it better or do it over? What can I do when as an employer when I get that form if I have questions about it?
Not uncommon. I mean, it could be as basic as we all know doctors' handwriting, right? It could be very difficult to read at times. There may be points of clarification. And, to the extent it's a point of clarification, I'm completely comfortable with a quick call to the office of the provider to clarify either what is written or if there may be a discrepancy, maybe two different parts of the form contain information that don't quite line up, for example, on a return to work date. Completely fine to follow up on that, but I would, again, advise the point of that call is really clarification about what has been set forth in that form. It's not a, open range to discuss every medical condition that might be in an employee's file, right? That would be definitely problematic. It's a limited inquiry, and it's a limited inquiry to acquire the information you need to finalize and either approve or disapprove the request for leave.
Yeah, and so our listeners know because I'm sure some of them have dealt with this form and some of them have not. And maybe they'll go online and find this form quickly. But it's important to note that that form does not have a diagnosis on it necessarily. Now, sometimes doctors will put it in the comments, but many times it will just state that the person has been seen and has a need for a leave, and there may be dates for a follow up, things to that effect. But it will not give a diagnosis, and it is not your place as an employer to ask for the diagnosis or hey, give me more reasons here. But instead, as George mentioned just a moment ago, if one place on the form says the person needs to be out for 6 weeks, but then the anticipated return to work date is 8 weeks away, you certainly have the ability to call the doctor's office and point out that there's a discrepancy. And we need to understand that. And personally, I like to tell the employers I would rather that they call the doctor's office to get an email address and then send their question as an email. That way, you're not getting into a lot of back and forth where you may get information that you don't necessarily need, but you can get your one question answered. Now, George, let me ask you this. What happens? What rights do the employers have if they just disagree with the medical provider? Because I know there's a perception, whether it's true or not, we can debate, but there's a perception that an employee can go to a doctor and get the doctor to say anything the employee wants. So, if an employee is looking to be put out on leave, they can get that done. What happens if the employer just doesn't think there is a need for leave?
There are some mechanisms. So, and this gets into the different paths of how a request for leave could potentially be denied. I think the cleanest path is eligibility. If they don't meet the basic 12 months or the 1,250 hours, that's a clean path to deny the leave. And that's step one if there is a disagreement. If we get that medical certification back, and Jeff and I talked about this offline, I think he and I, on one hand, in our entire practice, can count the amount of times that an employer pushed back on the information set forth in a certification, provided that certification form is completed in full. If something's missing, that's a different story. So if you can point to some particular reason why you may doubt or call into question the information in a certification form, the regs do provide a mechanism that you can get a second or even third opinion. But the takeaway is that I think that is going to be a very, very limited circumstance. And the legal risk of pressing back, of course, will take the form of an interference claim that you are simply just going beyond the scope of the rules and regulations, and it's tantamount to denying someone their request for leave. So my advice is proceed with caution in that circumstance and consult with an attorney to make sure that you're not running afoul of the act itself or regulation.
Oh, definitely. And one of the things that has been made clear through not only judges in cases, but also through regulation is that you may not, as a non-doctor, non-medical professional, substitute your judgment for that of a medical professional. In other words, you can't say, well, I'm the one who sees you and I can see that you don't need this medical leave. You're not a doctor. And if you're not a doctor, you don't have the ability to just say that. The other part of what you were saying, I think I really want to highlight, and that is to deny leave or to question leave and then say, okay, well, let's get a second opinion. The person is going to remain out while that second opinion is being obtained. And if the second opinion confirms what the employee said, well, there is no third opinion in that case. If the second opinion says the employee doesn't need the leave, then what the regulations require is that you and the employee agree on a third doctor, and that doctor's decision will become binding. But what happens is it takes a while for each of these things to happen. You're going to be at your 12 weeks by the time you get that third opinion. So now you've expended time, you've expended money, you have alienated this employee. They've gotten the leave. And what have you accomplished? Almost nothing. So I am not a huge fan of the second and third opinions from a practical standpoint as much as anything. Now, one of the things that we didn't touch on yet, George, but I want to circle back to it because looking at my notes for today, I wanted to make sure we hit this, is that some FMLA leaves require an employee to ask in advance. Can you kind of explain to our listeners the rule for having to ask in advance?
General rule is that if, for example, if you have an employee that's going out on a planned medical procedure, the expectation is that 30 days notice would be provided to the employer so that it can plan appropriately. But recognizing life really rarely works in that particular way, there are a number of safety valves built into that rule. And essentially is that if 30 days notice is not possible, the rule is that notice must be given as soon as practicable and possible. That, as you can imagine, is a very quick shifting scale. I know we have an example sometimes of, on a Sunday night, you have a heart attack and you don't show up at work on Monday. That's a perfect example of, well, you'll get notice as soon as practicable. That is, as soon as you're conscious or able to convey to somebody to give a call to your employer, that's going to be sufficient notice, even though it may be less than 24 hours notice. So as with everything in employment law, it's a case-by-case analysis, not a bright line rule, and it really depends on the circumstances you're presented with.
So let's assume the person has asked for leave, they've been granted leave, and they're getting ready to come back. Let's say we are 10, 11 weeks in. And I know I've gotten this call, and I know, George, you've gotten this call as well. Get a call from an employer who says, things have been running really smoothly without this employee. Do we have to bring them back? What do you tell people in that situation, George?
Well, in that specific circumstance where it's the flashlight is really focused on this individual, you are entering into very, very dangerous territory in the form of a retaliation claim, and as well as an interference claim, because in your case, they have at least 2 weeks left of leave. So there are circumstances, the FMLA does recognize that just because someone is out on leave and, business circumstances change, or there's a job elimination, you don't have to just keep open a job if financial situation or business necessity changes. But to do that, as I think Jeff will agree with me, whenever you do it with only one person and that employee is on FMLA leave, there's a tremendous amount of legal risk. If you're doing a department or a division where there's multiple employees involved, you're on stronger legal footing. But again, you got to proceed with caution because of various claims and including a potential retaliation claim, which are notoriously more difficult to defend. And they typically will make their way to a jury trial and not be dismissed at summary judgment. So I guess my advice is, if you're going to do anything of that nature, proceed very carefully.
I will tell you that I have told clients consistently, absolutely, you bring the person back. And you certainly don't let one person go and have that person be the one who was out on FMLA leave. Now, again, if it is a larger layoff where it's perhaps the 10 most recently hired and this person happens to fall in there, you're in much, much stronger grounds. But as far as that one person scenario, I would say absolutely do not let the person go. You are asking for a lawsuit. So let's talk about when the person actually comes back. And what the law requires is that they be returned to the same or an equivalent position. And when looking at equivalent, you're looking at equivalent pay, equivalent responsibilities, equivalent shift. You can't say, oh, well, it's the same job, we're just putting you on third shift. That's not equivalent under the law. But when people return is when we see really the biggest potential risk, and that's a risk of a retaliation claim. So what kind of things, George, can lead to a retaliation claim?
Yeah. So, just backing up so all the listeners are on the same page, when we say retaliation, what it means is, under the law, if you engage in a protected activity, and we're talking about FMLA today, if you request FMLA leave or you take FMLA leave, you have engaged in a legally recognized protected activity. And the theory is that if you suffer an adverse employment action because you engaged in that activity, your federal rights have been violated, period. Timing becomes very critical. So in Jeff's hypothetical, where we generally have someone coming back to work, the typical scenario that we see is that, well, the person was out of work on a continuous leave, job duties, responsibilities may have been shifted to someone else, and lo and behold, we learn, wow, this person may not have been doing all that great of a job, and there's errors, and there's grounds to discipline the employee, and the person's put on a PIP when they shortly come back from FMLA leave. That's arguably an adverse employment action, and that is a perfect example of how the beginnings of a retaliation claim start, because inevitably, in my experience, once this path starts with a performance improvement plan, many times it results in an ultimate termination. And then that ultimately results in an EEOC charge being filed, or in this case with FMLA going directly into court. And lo and behold, there'll be a retaliation claim based on that timeline.
Absolutely. And I always tell employers that it is best to evaluate the employee's performance after they come back. You're certainly free to do that, but you should not say, hey, well, the first day you come back, you know what, we need to talk about what we learned while you were gone. And we discovered that you weren't doing your job nearly as well as your replacement for a while. That's going to lead to problems. And in the retaliation world, George, and I know you've had some experience in this area, what kind of potential liability are employers looking at in a retaliation claim? I mean, obviously, there's attorney's fees for defending themselves, and these are not inexpensive cases. And as you said, it's unlikely to get dismissed on either a motion to dismiss or summary judgment. So you're looking at expenses going all the way to trial. But correct me if I'm wrong, these can be rather large liability numbers on top of that, correct?
Sure. Even in a single plaintiff case that's not class or collective action, for example, under wage and hour issues, I found a case out of the Southern District of Texas from June of 2021 that provides an excellent example of how an employer can find itself in a very difficult position if it chooses to litigate an FMLA retaliation claim all the way to a jury. The case is Wooten versus Invesco. And in that case, the facts basically follow the hypothetical that Jeff and I were just talking about. Someone goes out on FMLA leave, that employee returns. And ultimately, when she returns, she finds that her badge has been deactivated, her emails are deactivated. And while the employer remedies those issues, the employer almost immediately, in short order, puts her on a performance improvement plan based on all these alleged instances that they found while she was actually on leave. And the focus on this employee continued all the way up until her termination. And her termination occurred just about 5 months after she returned from leave. The matter ultimately proceeded to a jury, and the jury awarded the following damages. And in the employment world, you recognize that damages take many different forms, but let's add them up. She was awarded back pay in the amount of almost $400,000. Since this is a FMLA case, liquidated damages in the same amount were awarded, so it's basically double. Punitive damages were awarded in the amount of over $600,000. Attorney's fees, because this is fee shifting and the employer lost, were over $300,000.
So wait a minute. My quick math says $1.7 million?
Just shy of $1.7 million for a single plaintiff FMLA retaliation case.
Wow. And that's why we tell employers that you need to make sure you get this stuff right, because that is a scary number for a single plaintiff. So, George, I think it's always good. As you know, I like to end each episode with some takeaways, some things that employers can take with them after listening to this to make sure that they're in a little better spot. So I'll put out one if you want to throw out another one. So the first one I have is that FMLA leave is an entitlement. It's not a time for negotiation. If somebody requests the leave and they provide you with the appropriate doctor certification, grant them the leave. Failing to do so amounts to a violation of the Family and Medical Leave Act. It's either an interference claim is the most common one, and they are expensive cases. They are difficult cases in that if the employee has provided all of the documentation that they are required to under the law, and they are eligible under the law, it is difficult for an employer to establish a reason for denying the leave. George, how about one for you?
Do not forget the legal claim of retaliation. It's probably one of the most important things not to lose sight of. Again, I covered this already, but reason being is that they're very difficult to get dismissed before they end up before a jury. And in my experience, where these claims really begin to stem from is the frontline management team. Now, if you're fortunate enough to have an HR department that is up to speed on these types of claims, usually HR will not run completely afoul. But what I find is that the frontline managers get very frustrated dealing with someone on leave, and either stray remarks may be made that could be tantamount to an interference claim, or when that person comes back from leave, they make the person's life so miserable and treat them differently because of taking that leave. And that is the type of evidence that a plaintiff's attorney is looking for to take on one of these types of claims. And I think the solution is training. Managers need to understand the consequences. And I think managers will be very receptive if they have a retaliation claim to a $1.7 million hit as a line item on a budget. They will listen and they will not want to engage in this type of behavior. So training is absolutely critical.
I agree with that. And the last takeaway that I will say is every FMLA case is fact specific. It's important to know those and to look at everyone individually. Also, the FMLA is in many places very technical and not always what you would expect it to be. Approximately 2 years ago or so, I gave a presentation on the FMLA to about 80 HR professionals. And during that presentation, I gave them 10 hypotheticals right out of the regulations and said, does this person qualify for leave or not, et cetera. And of the 80 HR professionals, not one got all 10 questions right. These are people who deal with the FMLA on a regular basis. So there are a lot of twists and turns in the FMLA. So you need to be careful. And as George said, if you have an unusual question, consult your employment attorney because that's our job. So with that, I want to thank all of you for joining us on this episode of the Employment Law Counselor Podcast, where we try to make sense of the world of labor and employment law. I thank George Morrison for joining me again. Thank you again, George.
My pleasure.
If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. We're trying to get our numbers up. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.